Yes, thank you very much for the introductions and for the invitation that brought us to Goa for the first time in our lives. Very good experience we had the whole weekend. And let's get this on the road. So the music you heard a little bit at the start is from the movie in which these two persons play a role. I switched the pictures, so it's us. Because yesterday evening we realized that we are like the movie characters, the Blues Brothers. If you know about it, it's we are on a mission. That's the theme of the movie, and we are on a mission. So let's see what mission do we have. So today I ethics and European law, but even other laws. Let's see if this one works. Maybe I need to put it on. That's better. Oh my God. So we already heard the CV, so I'm going to skip it. And I guess that also goes for class. So I'm making a decision on his behalf. That's what AI does for you. It takes decisions. But let's start with the basics. So one basic thing is that everyone's talking about artificial intelligence, but we don't always know what it is and it's not. So how many of you here use artificial intelligence? 1, 2, 3, 4, 50%. Okay, what do you use? Tell me. ChatGPT, what a surprise. That's what everyone says.
Editing photographs.
Editing photographs. So you look like Photoshop, Lightroom.
Yeah.
Okay. How many of you have a smartphone? That's more or less everyone, right? How many of you have an iPhone? Not many. Do you use Siri on the iPhone? Siri is AI. If you don't have an iPhone, maybe you have a Google, an Android phone. Do you ever say, hey Google, and the phone helps you? That is artificial intelligence doing the work for you. So it's in everyone's life. It's much more than the few applications that we know about and are conscious about. But let's start with artificial intelligence and go back to the basics. Started in the mid-1950s, so it's already 70 years old. The biggest hype, maybe, is from the last 5, maybe 10 years, but in principle 5 years. AI was a big hype in the 1980s, and then it died. It was a big hype in the 1990s to 2000. It died again. This is like the third or fourth wave of AI being of interest. From the start, it was a combination between thinking about how humans think and behave, and how we can make computers behave as if they are intelligent humans. And it was in both directions. The modern AI is slightly different when we get to that. The other thing we need to think about is that AI started as any IT technology. It was programming. So you told the computer what to do, and then you hope that it did it. Programming is using programming language, which means you can read, and if you understand the language, you can understand what will happen. That's called symbolic AI. Modern AI is sub-symbolic AI. It is almost as if the brain works from neuron to neuron. So it's a big network of information that is passed on or not using different ways. There, we cannot understand what's going on. And that's one of the main problems with modern AI. We look at it and we cannot understand what will happen from input to output. So that's something to think about. AI is more than ChatGPT. AI can also be programmed, it still exists. So when we talk about AI, we need to think, what is it actually that we're talking about? Now, since it was this very hype stuff, if you talk about ChatGPT is a big network, it has 1.8 trillion parameters. It's impossible to understand. No human brain can So what happens? We press the panic button because it's now out in the wild and we don't know what it does. And that's dangerous for society. The technology that everyone can use for almost free and we have no clue. So we have this AI beast and we need to take it. So what did people say? We need ethics, we need law. That started also about 5 years ago. Then the big wave of new AI was coming. There's also some other ideas on how to take the beast, but we can get to that there. But get back to what it is that you do from a law perspective. So one thing to think about is that governance, making sure things go in the right way, has to do with artifacts, anything that's human-made that can make a bad impression for society. We need to have some kind of regulation for, which can be voluntary from the people who make the technology or from the outside. Now, as AI is human designed, either programmed or using this modern technology, we can use the same way to regulate it. And that's what law means. So, the other part to think about that law itself is also human-made. Laws change over time. They adapt. Laws reflect society. The laws in India and Europe are different because they have a different background. And the same goes for AI in principle. Now ChatGPT comes from the US, and you can think, is technology developed from the US a good thing for India? Maybe, maybe not. Is it a good thing for Europe? Maybe, maybe not. We need to think about these things. It's available everywhere, but why is it the way it is? Who decided what it should look like and what it should do? So, if you think about government, we want to make the world a good place, and it shouldn't get worse by technology. So it's all about social order. This one I can skip. This one I can go through shortly. So if we have a simple society with only human beings, we have ways to produce social order. We have conventions on how we behave or how we dress. We have norms that are a bit more steering, but still, it is a human decision and the oversight is by humans. Once things are complicated, we get something in there that's called institutions. Law can be an institution. That puts a different models into their humans and non-humans interacting in one system. And that's why we in the law talk about natural legal entities and artificial legal entities. Right? We need to regulate them. And that interaction becomes even more problematic once we get these intelligent, human-like machines in there. And that's what the challenge is. Now, as AI is about 70 years old, this is nothing new. It's just that it never was that widely available, so there was no panic. Now it's widely available, so we have a panic. But in principle, there's nothing new. Which is interesting, we could have had these laws 70 years ago. But it's not there. So if you think about this soft governance with conventions and norms, that's what the industry has tried to do. They try to make up their own rules and say, if we tell the customers that we behave nicely, there is no problem. And we can define what nicely is and is not. Of course, that doesn't really work. We all know that if you give industry all power, it doesn't really work for the social order of society, but it works for the profit of the company. That's a problem. So, what else happens? certain organizations that organize the computer scientists, so IEEE and ACM, and they have a set of rules to that. Still, not law. There's no police or government, there's no judge involved, it's all internal. But these standards, they get quite close to hard law. So Claes, can we see standards and norms as equal to law?
All right, that is a big question. So thank you very much, Professor Henricus Verhagen. And the answer in the European Union legal context is actually yes, but it is quite revolutionary that standards, technological standards are considered to be law. Because, you know, in the normal system in a country, law is anchored in a democratic process. You have an election here today, you elected your representatives, they can decide the rules at some level. It's the same with national level and regional level. You elect your representatives and they enact law. But the European Union is another breed, so to speak. It's a sui generis policy. It is actually made based on international agreement between sovereign states. Nowadays, we have 27 states. Originally, there were 6 sovereign states, arch enemies in a war-torn continent decided to join forces, particularly in order to promote trade and economic growth. So the whole process starts with an intention to create one internal market. But in order to do so, you need to transfer a lot of normative powers to the supranational institutions. So we have an unforeseen, unprecedented amount of powers transferred from the national governments and parliaments in particular to the EU level or the European communities at the time. So on the one hand side, you got a community which was a new breed, a new bird, so to speak, a strange bird perhaps, with a lot of powers to regulate the market and integrate the market. First of all, deregulate, you can say, to take away the state control. And when you have taken away the state control, you need a lot of specific rules to make trade function. So you had a lot of powers transferred in that regard to the EC. But the member states, they were reluctant to transfer constitutional powers to the Union, such as fundamental rights. And at the same time, this was really an issue in Europe after 1945, fundamental rights, and in particular also after the United Nations Charter and Declaration and all that, which was operationalized already in the 50s through the European Convention on Human Rights. So human rights was a big deal in Europe, but the EC did not have power to regulate human rights at all. So there was a tension there with the German Constitutional Court, the Bundesverfassungsgericht, the Soumyaa debacle. It went on for 20 years. It started in the early 1970s and I would say ended in the early 1990s, even though the German Supreme Court, Bundesverfassungsgericht, said already in 86 that, okay, you have sufficiently recognized fundamental rights to a sufficient degree that we should accept your rulings. But so what the European Court of Justice did was to say that we are not bound by the European Convention on Human Rights, we are not bound by the national constitutions, but we recognize fundamental rights in the convention system and in the national constitutions as general principles. So we take them into consideration. And the golden rule in EU law is proportionality. So you can always reconcile different public interest and fundamental rights on the principle of proportionality, which means that necessary limitations in all rights and interests are required in order to ensure consistency in the legal system. So this is what you did, but still it took some steps from the early 1990s until 2009, until you have, I would say, a mature legal union system. to make a long story short, the current basic framework of the European Union consists of 3 documents. It's a treaty of the European Union, which encompasses some basic principles and definitions of the institutions. And then you have the Treaty on the Functioning of the European Union, the TFU, which operationalizes this in a bit, but also specifies procedures. It can be legislative procedures or court procedures, and also contains some substantive laws, free movement rules. So this is the basic structure, and then we have the EU Charter, which was originally just a policy document, again just principles, but it was elevated to primary law through the Lisbon revision in 2009, so it had the same legal values as the treaties. So now we have a really clear value basis since 2009 in the European Union. There was an attempt in the noughties, in the early first decade of the new millennium, to create a European constitution, but the people of Europe voted against it in 2 referendums, in France and in the Netherlands, Holland. And so that was not a saleable way. So instead they come up with this more complicated structure, but still this is very much like a constitution of Europe, because we now need always to take the Charter into consideration. And again, this principle of proportionality is stipulated, written into Article 52 in the Charter, saying that you can always limit all these rights if it's necessary to reconcile them with other public interest or rights. So this is the golden rules, proportionality. And then in this system, we also conferred a lot of powers to the supranational institutions to enact legislation. We have 2 main acts. It's the regulations, which apply as law throughout the European Union, and directives, which should be implemented through the national systems in order to have the same legal standards, a level playing field. And you can see now everything has turned 180 degrees. Now the European Union is promoting the values, and the member states are again a little bit politically driven, taking easily on fundamental rights, having their own agendas and so on and so forth. But now the European Union has become the guarantor of fundamental rights, and it's promoting, for instance, also fundamental rights in the digitalization era. So we have a lot of legislation handed down from the EU institutions with regard to, for instance, artificial intelligence. And as you probably know, there was an artificial act which entered into force now in the European Union on the 1st of August this year. So we have a legal framework, and I hope we can come back to this a little bit later. But to say, just to summarize, that the legislative acts in the European Union context are regulations, directives, and generally applicable decisions directed to the member state, which apply as law to everyone in the same situation, so to speak. But also, because of this Elliott ruling from 2016, standards are recognized as law. So that is the answer. And this, the reason for this, this case was about a German guy who published technological standards, and the standardization organization said, no, these are our private standards. You are making a copyright infringement by publishing them. So the case was about copyright infringement. And then the German court asked for a clarification from the European Court of Justice in this regard. And the court said, no, you don't have copyrights because these standards are law. They're public documents. They should be publicly available. But at the same time, they say that these standards are law. They open up a door because, and I think it's very clever, because you will need to regulate much more through standards than through legislation in this fast-moving legal landscape, so to speak, with new technologies. And the legislators, the regulators, they don't have the knowledge, they don't know more than you about technology, so how should they be able to legislate? No, you need to involve the stakeholders and regulate through standards which are tailored for different sectors. But I would say, just to wrap this up, the reason why we can do this in the European Union is that it's not anchored in a democratic process, it's anchored in international agreements. So that would be my answer to your question.
Thank you, Claes. So, this one I will skip for now, but this one we can talk a little bit about. So if you read a little bit about AI and ethics, you see certain words such as responsible AI, And that sounds very nice, AI that is responsible. But of course, AI is an artifact, it's not a moral agent, so it cannot be responsible. So what they probably mean is responsible design of artificial intelligence, to put a human back into the process. It's the developers being responsible, not the AI. The AI reflects it perhaps. So that's also something to think about. Now, if you look at responsible AI in practice, I told you about the high-level expert group in the EU that had this idea about standards for artificial intelligence. They described what responsible AI is all about. So, what I and some colleagues did, we talked to people who were developing artificial intelligence programs for public organizations in Sweden about 2 years after these standards had been published, thinking these people should know what they're doing. Half of them didn't know about them. And the other half said, this is too difficult. These standards that the group decided upon are very abstract. They're about principles, but they don't translate them into practice, as in the work practice of people developing AI. And that's why these standards that then become law are a little bit problematic still. We need to have a translation from the abstract to the concrete, otherwise they will never change reality. And that's what you want to do with governments. The other term you may have heard is like trustworthy AI. Sounds also fantastic. It's also just the same argument. It looks very much on technology, as in the program works correctly, and very little on the effect of the programs in human lives. And that's where the problems are. That technology works or doesn't work is one part, but what it creates in social life, that's where the panic button is, that's where the problems are. So the focus, I think, is on the wrong part. I'm going to leave it at that in this case, and move on a little bit. I'm going to skip this one also, I'm going to go to this one. So a few years ago, some researchers organized an online experiment. The online experiment is based upon something you may have heard about. It's the trolley problem, which is an example of an ethical dilemma. The trolley problem is that there's a streetcar on the rails and it's out of control. And you can decide which direction it takes, if it goes straight or to the side. And there's different people on the track that will die. And you have to make a decision, who will die? This experiment is slightly more elaborate in the sense of different scenarios. And you can think of it as a self-driving car that needs to decide, do I kill the dog or do I kill grandma? Especially my grandma, right? You can play this, it's still online. We don't really have time for that today, it takes a little bit of time. But it gives you insight in how you are thinking from an ethical perspective. And if you play it, you get a summary that says, you are this type of person. And it might be that in this group, there's different types of persons. Now, if in this group, with people who may be with a quite similar background, have different ideas of what is right and wrong, how can we have a machine that decides correctly what is right and wrong if we ourselves don't even agree on what's right and wrong? That's one problem. What they tried to do also with the experiment is to see how these opinions on what's right and wrong differ over the whole world. So we could say that in China, people are more collective, so they would think in this way, whereas in Sweden, people are more individualistic, so they think in a different way. Now that is interesting. But what do they want to do with it? Do they want to make a self-driving car that will make different decisions in different countries? Maybe. But is this the right way to collect data? Probably not. The experiments are very artificial. There's no real blood. There's no pain. The real world is much more messy than the story experiments. Yet, within AI, we have not thought much better than this strange way to find out what people actually think and how to put it in the machine. Now think back to how AI started, right? We have psychology and computer science that try to interact. This is computer scientists forgetting about the social sciences and psychology. They don't understand people. It's awful. These are my colleagues. Why do you not think? Or talk to people. Or talk to people who know social theories, psychology, and get better things to do from an ethical perspective. But the law, of course, is not only about ethics. I'm going to skip this. And maybe also this one. I think this is a better starting point. So when you, as a lawmaker, want to think about artificial intelligence, and we have seen these problems with machines making decisions about right and wrong, like that, you need to know a little bit about how AI is developed. So it starts with an idea, and it ends when the product is no longer on the market. And in between there's different phases. Now the development phase is only after the idea. So that starts with designing, verification, then it puts to use, right? Then we get some feedback loops, we see that things go wrong, we need to update the program, and then all of a sudden we need to have something else. But these, the ethical input, and these three main categories, they should already start with the idea. We should think before we develop. How would we attack transparency? How do we think about privacy and security? So the government is all the way. So getting law involved when we are here is too late. And that's why you need to stand a little bit about the technology and see when can we, from the government's perspective, have an influence on AI development. Now for the AI firms, they do it here more or less. The Californian slogan is we break it and then we see if we need to fix it. And that's very bad for society, right? So if you let technology people and companies rule the world, we end up with a broken world. And that's not what we want. And that's why we need ideas such as the AI Act. And I think we get to it. There's nothing else to keep a few. I think we go here. So the AI Act, what does it do, Claes?
Okay, now we're talking. We are coming into hardcore law, AI Act. But, as Professor Henricus Verhagen said, what can law do really for society here? Because the system is very reactive. It's based on ex post facto enforcement. And what is ex post facto enforcement? The main idea of law here is that something happens, someone sees that person doing something, bringing that person before a court, and that person is sentenced to prison 2-3 years later. That will not function in a digital environment. It's too slow. As ex post facto is no longer a saleable way or saleable route to regulation. So we need something else. And this is what the AI Act is about. It's an ex ante regulation. You set up a system to control things in advance. But, and this is also an important point to be made, that the AI Act only applies to high-risk AI systems. And what is a high-risk AI system? Is it some kind of new technology that is high risk in itself? No, it's not. The technology can be used for all kinds of stuff. It can be very benevolent and non-risk at all. It's just a refrigerator working in a smooth way. That is fine. So the high-risk element is defined by deployment. And normally, we say that, or generally speaking, if you deploy an AI system in the public sector, it is probably high risk. Also, if you deploy an AI device in services of general economic interest, what is that? It's banking, it can be medical, healthcare sector, and so on and so forth. It is probably also high risk. But what might be most interesting for the general public is that this regulation ties into existing public product standards regulations. We already have a lot of regulation of cars and toys and elevators and you name it. So we have this system already in place, an ex ante system to certify things to be put on the European market and to monitor the things over time. So this is it's nothing new, but of course, in some years from now, we will have AI systems embedded in a lot of products. This would be called Internet of Things. You know, self-driving cars, whatever, your refrigerator, whatever you have, will take some kind of decisions by its own motion. So these products will also need a regulation of AI. And the main challenge here for the member states is to decide who shall do this, because we have already today standardization organizations and public authorities monitoring products on the internal market. But who has the knowledge to monitor the functioning of an AI system? Do these authorities have that? No, maybe not. I will come back to data protection eventually, and of course we have data protection authorities specializing in that. Should they take care of all AI systems? No, probably not. So this is the homework to be done for the governments of the member states to set up the institutional framework that will certify and monitor high-risk AI systems. Finally, we're talking about an AI system that is deployed with regard to employment situations, monitoring of labor, that is also by definition a high-risk system. So, of course, the AI system is not a legal entity. You can't regulate AI. And even if you would come up with a model where you regulate AI, that would be a disaster for the normative system called law, because then we could blame the AI system. No, we did nothing wrong. We washed our hands of this. It was the machine that took this decision. Okay, what can law do about that? Well, basically nothing. You can turn off the machine, that's it. So we need to actually address human beings or their legal constructions or companies or public authorities and say that they are responsible for this and they are responsible for that. So this in itself is a trick, really. But then as mentioned also, these legal entities, even if we know who was providing this machine, who was deploying it in this high-risk way, it is still a matter of regulating this ex ante in advance. So we have to have communication all the time. And of course, the first step of this is to help the industry to develop standards. So the public authorities, they will be good in certain areas, of course, and they can say that this is the legal standards we need to implement somehow through your algorithms. And then the industry has to develop this, because the civil servant does not know how to program an AI system. I mean, I don't know that. So, I mean, we can have good ideas about what is good law. This should be we should have the same right as human beings, even in a society that is based on AI decisions. But how do we do it when we can't run after all AI systems and checking them? No, we must program them in a certain way, if that is possible. And this is the main issue. And the main question I pass to you, Professor Verhagen, is it possible to program a system that is all the time learning in accordance with human interests?
Thank you, Claes. So, I think the problem is that if you think back what we had in the start, right? We had ChatGPT. Now ChatGPT had 1.8 trillion parameters that you can't really understand how they connect to each other. You can easily see that it's impossible to program it on the level of the system itself. What you could do is that before the system decides what the answer will be, you could check if the answer is within a certain frame. But then the question is, can you really foresee that it always will be treating people correctly? I think we have a big problem there, and the problem is bigger than technology can solve. But talking about ChatGPT, if you think back to what Claes said about high risk, so ChatGPT is not high risk, but building a health application using ChatGPT is high risk. So that's how we need to think about these things. We do not regulate the content of the technology, but how it is being put to use. So keep that in mind. And then from the context of use, we may need to think of, okay, how can we think when we have an idea what the risks are? How can we, as developers, understand that? But now we have also other people, we have the standards organizations who define things for us, but we need also to think about how we affect society. So, if you think about this picture, and think about everyone who is involved in an AI system, here we have the core developer. That's only one of the roles in the system. So we have a platform on which the system runs. The AI system can run on your device, but if you say Siri or Hey Google, it's not on your device anymore, it's on a platform. It's in the cloud. How do we regulate that? Do we need to regulate that? And what happens along the line, right? We are the users. But we as users are not always the final station of the decision. So for example, if I'm a civil servant making decisions about people getting sick leave money, I may use the AI system as a civil servant, but actually the people who the decision is about should also be involved. They should trust the decision. So, how do we get these? Well, they're called data subject. They're like, if you call, the victims of the decision. And here we have some people who Claes was talking about. We have auditors and evaluators that may be internal to the development system or external, as in outside control. And this is us. This is the lawmakers, right? We're also in the picture. So all these roles need to interact. And this is from the International Standards Organization. I think the standard that in the end will prevail as law in this context. So all these roles make life difficult. So can the law help us to make life easier, Claes?
Well, that's a very good question, because it's like a hot potatoes. We are throwing it back and forth. Who shall do what and when and so on and so forth. And no one sits with a crystal ball having the final answer. But on the other hand side, if you would be in a politically driven polity, your decision makers could just decide one way or the other. But in the European Union, with this complexity, normative complexity, with 27 states and their own systems and all that, we only had a value basis. And what justifies the regulation is that all measures fit into this value basis. So we need to reconcile interest on the basis of proportionality. And on the one hand side, when it comes to the AI industry, is the freedom to conduct a business, economic freedom. That is the American approach. Yes, just go for it. Grab all, take all the opportunities you can, grab as much data you can, and develop your things, and then we'll see what happens in California, as Harpo said. But we have a completely different tradition in Europe. Our tradition is not public control and to regulate market and intervene and structure things. On the continent, we have codification. In the UK system, we have, of course, more steer decisions and court-driven development. But so, I think when it comes to AI, one particular challenge that needs to be addressed, and this is addressed in this AI Act, which I think is a very convincing piece of legislation because it just sets up an administrative framework and a system for checks and balances. We have Article 14, because in contrast to your current car, it's just approved by some authorities to sell this car in the market, and that's it. You put it in the market, you sell it, and then you have a secondary market, perhaps, and repair downstream services. But here, we have a thing that develops and learns. So you must have continuous monitoring and continuous oversight over the system. And this is written into Article 14 of the GDPR. So someone, an external person, must monitor the system and be able to react to signals from the systems 24/7 basically. So, but then, who shall do what in this regulatory system? Well, we don't have the answer because the legislator has simplified this, perhaps oversimplified things, by saying that we have two categories of persons here. We have providers of the systems and we have deployers, and the deployers shall have human oversight continuously over the system. Okay, but when does the provision of the system end? Is it just about the hardware, just providing some chips? Is that it? Then it's okay. Well, we don't know. We have one indication here in recital 73 in the preamble to the AI Act, stating that human oversight measures should be identified by the provider of the system before it's placing on the market or putting into service. Example given by inbuilt operational constraints that cannot be overridden by the system itself, and it's responsive to the human operator. That much human language can do. I mean, we can't come up with a more on a general level, on a more precise obligation for the provider when it comes to protection of human rights continuously. We could perhaps identify some red lines. The system can't do this, the system can't do that. It's absolute a prohibition for the system. And then it must also be able to communicate with humans and say that something is going on here, you have to check this or whatever it might be. But that's it, because the system learns and changes. And also, is that a part of the production of the system, to train it and learn it? I mean, this is the weakness of the regulation. It's oversimplified. We can't decide at this level who is in what category here. Who is the provider, who is the deployer? So, we also have an ex-ante approach, the so-called assessment of impact, and this applies in many instances when it comes to high-risk AI systems, but not all. So you must test it basically. You must see how does it learn in this way or the other. But still, this is the ex-ante. We have to do it before it's put in the market, and if it measures up to these standards, then it's okay. You can put it on the market basically. Then what happens is a gray zone, a mystery to all of us, until it signals something to the person overseeing it, and the person does not take action. Then, of course, that's liability of the deployer overseeing it. So much we know, but there's still a lot of question marks here. And I might come with a really shocking news that sometimes you discuss the black box problem as a legal problem. How do we go about it? If we can't really understand what the machine was doing here, how can we regulate that? The answer might be, well, we don't need to regulate it because it's prohibited. It's a matter for the industry to solve, and unless you solve it, you can't put your system on the market. And this applies to Indian companies, this applies to American companies, it applies to European companies. If they can't ensure a certain level of transparency, you can't put the system on the market. That is the takeaway from the AI Act when it comes to high-risk system. It might be shocking news for everyone that we can't test this as Americans. No, that's the main idea. We put human interest first and foremost, then you can develop your products. And also, we have this system of sandboxes, so you can develop and test things before you put it on the market. But if you want to use it, deploy it, then it must meet these standards, which actually means that you can't have black box problems when it comes to AI, high-risk AI systems. So that would be my answer at this point.
Wrap up?
Yes.
So I think we have a few more slides. I will leave it here with this in the interest of time. But I think the conclusion is that ChatGPT is very popular now, but pretty soon illegal in Europe because we don't know what it's doing. So be prepared for a world without ChatGPT. We survived before, we may survive without it even after its existence. And we will make the slides available if you want, but I think we have time for some questions now. And so I see we have an extra microphone here. And we will just be sitting closer to each other so we can see share.
Good afternoon, sir. Thank you for a wonderful presentation. So I've got 3 questions. First, I would like to ask your opinion. Like in the prehistoric times, it was more like the strongest would survive, where the person's physical dominance would basically decide whether he would prevail among the others. Now, it is more of the savviest will survive. But if you are not technologically savvy, then it's going to be a big detriment to you. That's my first question to you. The second one is...
If you would, I can answer that straight away. So, it is a misquote from Darwin. Darwin said it's the fittest. And it's not fit in the sense of physical fitness, it is the most fit. So the most adapted to the circumstances. So things have not changed. Savvy is the new powerful. The world is to the nerds.
Well, sorry, this is very interesting actually, because I would like to add something to this, Darwinism, that is a reductionist theory. Darwinism is that you start with a broad variety of species and some dies out and some are more fit and survives. But where did all these species come from in the first place? That's just one thought to share with you.
I agree. But this ties into where I started and I said that all artifacts are products of their time. And that products of the time also implies that we need to adapt to the times in which we live. But we can take your second question.
Yes. My second question is, like you said, that the times that people consider, especially in regulation or governance, before they put the policy, it's too late because they are in the stage of deployment, many of these companies who are putting out their products. But there's already a lot of literature that exists in terms of Isaac Asimov, who has created great literature which is sound in science as well as it poses a lot of questions, especially in the slide that we showed about the moral machine, about the dilemmas that robotics, which is very closely to where we are reaching now. Like you said, ChatGPT has already reached a stage where it can be said that having a sort of thinking mind. You can assume it, or you could be convinced as to thinking that it already has thinking mind. So that is one question. And do they consider those literatures while making those policies? Second one, Neil Stephenson had written a book called Snow Crash, in which he had basically in 1990s around, when he had talked about the metaverse and the virtual world, which is like a drug for people, which becomes like a drug for people in a dystopian world, which is also something that we are seeing with people who are so obsessed with screen times that they are not being able to have proper interpersonal conversations, and they are losing a lot of life skills that were earlier very prevalent amongst us. So those 2 points are which I wanted to your opening on. I have one more question, but I don't want to hog the mic.
Yes, I think I can try to answer part of it, and I'm sure that Claes also has some insights, and then what we can do is we can see if some other people have questions before you get another round. When you say the technology is already out there, it's too late to regulate, I'm thinking about the start of the airplane industry. Airplanes were already around before we started regulating lots of things about airplanes. And I think that's just not happening. We cannot regulate before technology arises. So, in that sense, we are always too late. But I wouldn't say it's too late. We're still relatively early on. This new AI being available everywhere is 5 years. ChatGPT is 1.5 years. And that's version 3, which is not very intelligent. Version 4, that's going to be out, is much better, but also much bigger. So I think we are in sync with regulation, but we shouldn't wait much longer, and that's why having the AI Act enforced from August 1st this year is just in time. The question is, it's the first one internationally as a law. The rest of the world might be slightly late, yes. So that would be my point on that one before we think about the last one. Do you have anything to add, Claes?
Well, I mean, again, a rather philosophical question. I think in the big picture, you know, the weakness of the Marxist system was not the idea to share things and distribute things in a better way, but the idea that some old guys would sit in a room and decide for 5 years how to allocate resources. And that was a much weaker way than to give everyone a chance to try their ideas along the lines of economic freedom. So I think the basic idea of economic freedom is very important to develop things, but you always develop it in relation to standardization. We went to a museum yesterday and we looked at this barter economy, old barter economy here in Goa, where you have certain measures of what you had, milk or seed, or what you had, and you changed it. But of course, I mean, the size of these cups was rather important because, you know, if you get 0.5 more by trading with this guy, it's probably an advantage, but this guy loses out, and so on and so forth. So you need standardization, and this is nothing new. It's the same with the AI systems and the new digitalization era. We need standardization, both because of consumer protection, but also for the industry, because otherwise you have a company setting a standard that everyone needs to abide by, and then you have a lot of deadweight losses and a lot of competition problems with that. And this is what the European competition authorities are doing now, breaking up and intervening against big companies setting too much standards. So we want to have the industry, we want to have input from more people, more stakeholders to develop standards. So we developed a normative system along with the technology. And I think that law, as it was as a social phenomenon once upon a time, does not really fit the bill any longer. We can't regulate through law, through democratic processes and then law. We need to regulate in a more apt way, faster way, and this has to be involved the stakeholders who knows about these things. It's about trust as well, and about sanctions as well, but it's mostly about getting the technology right. And what we can do in Europe, as one of the biggest players in the world, is to kind of use the trading powers to export our values. It might not work. Maybe the Indian way will prevail. But now, the interesting development is in the United Nations, where we have now a process with experts setting up at least principles for AI deployment around the world. And that will be very important. So I don't think it's too late. It is a generic process. We have to follow, you know, the technology and at the same time be involved in the development of technology when we regulate in another way than before. So that would be my answer.
Thank you. I think we may think about your final point, but we let it.
Thanks, sir. Actually, it's a very nice session. Actually, I just want to know, like, this area, in new regulations, they have actually they have actually reduced the burden in the administration level. And they have actually given respect and rights, fundamental rights respect. So basically, I just want to know, like, what are the preventions of where is the exemption in AI which we can
Kör du, jag förstod inte riktigt vad frågan.
We have a slight interpretation problem here. So, if you say exemption, do you mean that certain technologies shouldn't be allowed? Sorry?
In all terms, as in terms of the administration or governance level, wherever the AI is used.
Aha. Well, I can tell det för sig. Thank you very much. And I think I try to answer or share some thoughts on this with you, because in the EU system there are general limitations when it comes to transfer of powers. So for instance, the whole military industry is outside the scope of this AI Act. And I would say that is the most important thing. The interesting thing from a constitutional point of view is that the organization of healthcare, for instance, is actually outside the normative powers of the Union. It's a national matter to organize your healthcare system. But during the pandemics, the member states realized that there's an advantage to coordinate our activities here as well through the EU institutions. So in accordance with Article 6 in the TFU, you have this assisting power of the European Union, which was applied in that case. But now I think this helped to broaden the kind of understanding of the transfer of power to the European Union, so they actually regulate the healthcare sector now, and there's a regulation underway regulating the European health data space. So this is actually now an EU competence only. So there are limitations when it comes to this EU powers to regulate AI for sure. Then of course you have the national level, and they're also bound by international standards, also the United Nations standards and things like that coming around the corner, so to speak. So there are limitations, but we don't have a general limitation for state interest. What we have within the scope of this regulation is a balancing on the principle of proportionality. So it can carry more weight to have a state interest than to have a private interest, for instance, education or something like that. So, but you still need to recognize, for instance, data protection also. So you can't just look at one absolute limitation. You have to always balance it on the principle of proportionality.
Just want to know, is it regulated through the international agreements? Is it regulated through the international agreements?
International agreements.
Agreements. International agreements. Yes, this is the external relations of the European Union in Article 207 in the Treaty on the Functioning of the European Union. And when it comes to trade, the European Union has exclusive powers here. So all the member states avail themselves of the powers to enter into trade agreements with third countries. But in some areas, if it goes beyond just trade agreements, and we'll talk about setting up international courts or things like that, then it goes beyond these exclusive powers of the Union. Then we need a mixed agreement with both the member states and the Union at the same time. This is, for instance, the CETA agreement with Canada. But this has proven to be very complicated, actually. So it is not up and running yet, and it didn't work with Americans. So it is complicated. The more advanced the international agreements becomes, the more the member states need to be involved, and that makes the process very difficult. But I think, if you ask me, that the future is international standards. I think the United Nations process now is very, very important. You can have some principles at least applying for everyone everywhere. I think that's the only really road ahead, because this is an international development, basically. Then you can try to promote your system more or less around the negotiation table, because you have so much trading power, and that is what everyone will try to do. But I think that this will be an international issue for a long time ahead now.
Yes, I hope that the United Nations and the International Standards Organization are on the same page in this process, because the ISO guidelines are very much normative for companies. Everyone wants and needs to follow the ISO standards. So if the ISO standards and the UN rule system are on the same page, I think a lot of these questions are solved.
Any more questions?
so much.